Okay. Good evening, everybody. Thank you for coming tonight to the planning board meeting of May 6th, 2025. So as we start our meeting, let's go ahead and stand and do the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Hey, thank you everyone for being here tonight, and appreciate we still have a crowd, which is great. We'll go ahead and start with an approval of our agenda for this evening.
Ms. Chair, I have one
Yes.
addition to the agenda.
Please.
I wanted to keep the attorney introduction as item A1, and then I wanted to make a new item A2, introduction of Rusty Darnell, the Assistant District Engineer for NCDOT.
Okay.
If it's the board's pleasure.
Great.
Mr. Chair, I also have two things I'd like to add. One was spoken to Mr. Malachek about. He is prepared to speak. If we could have a little discussion about House Bill 765. Michael, you want to do that during item D?
Yeah.
That's all right, Mr. Chair. The other thing, you can add this anywhere in there you'd like. I'm gonna call it the Mills River Crossing discussion, but I have several sub-bullet points,
As I would,
if that's okay with
I would expect no less.
with those, unless anyone else has anything to add. I'll make a motion to accept it.
I think yeah.
I just wanted to add to the agenda wherever and whenever of seeing if we can adjust the date for the June meeting. I won't be here, I won't be in the country actually on June 3rd, so.
Okay. Let's go ahead and add that.
So we need those to be added with G.
Well, I was gonna ask, do you want the Mills River Crossing discussion to be at the end of the meeting, or would you like to move that up possibly after the attorney introduction, or since we may have members, since we may have members of the audience here who may be
A3.
interested in that?
Is that what you're saying?
That may be,
That works.
okay.
Okay.
A3.
Okay, good. With that, does anyone on the board like to initiate a motion to?
Motion, we approve the agenda.
We have
A
a
second.
motion to approve. Second, do we have a vote on that?
Second.
Aye.
Aye.
No.
Aye. You. And we also need to approve the minutes of the April 1st meeting.
I make a motion to, oh Lord, I just thought I lost my train of thought. To approve the April 1st, 2025, minutes.
Second.
Can we have a vote on whether to approve the meeting minutes of the April 1st meeting?
Aye.
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 Universal. Michael, do we have to note that Lonnie is absent? Okay, awesome. Perfect. So moving on, to Michael, do you have any staff updates?
Yeah, just a couple brief announcements. I just wanted to let the board members know, we're gonna be continuing the floodplain ordinance discussion with council this Thursday at their meeting. Staff's been working behind the scenes to find example ordinances and basically draw comfort around what amount of fill is allowed, stuff like that. So that will be discussed, but just wanted to advise the board that's still moving forward. Everyone mostly knows this, but I just wanted to say it publicly on the record. The afternoon of Thursday, April 24th, I received a phone call and email from the Mills River Crossing Phase 4 developer formally withdrawing their application from consideration. And after staff received that, all the permits were canceled. That's why that is not on the agenda tonight. Lastly, spoke with our UDO consultant today, for developing the town's first unified development ordinance. So a comprehensive review and update of all our development codes. We are looking at June 10th for our next steering committee meeting. And I just wanted to float that out there since I know the majority of this board, sits on that committee. That would be the same night as a Board of Adjustment meeting, but we're expecting to cancel that due to lack of business. We tried to keep it on a Tuesday, again, knowing that board members would be available then.
You're asking for feedback right now.
Yes. Well, sorry, sure, yeah.
Yeah, so unfortunately, as I never miss any of these things, that's a week I can't do it all. I am on the board, but that's,
And I should have said this, it will be remote, so we're doing it over Zoom.
I'll be,
Yeah.
I'll send out a formal email. That was just a date we worked out this morning.
Okay.
But that's all I have.
Thank you.
Mhm.
Great. Does the board have any comments or updates they would like to make at this stage?
I
of
just
the
have a
meeting?
question actually, Mike, and that is if the application's withdrawn, there's a new, so that would they have to submit a brand new application and that would get a brand new date? Or is it a continuation of the original applications years ago?
No, it would be a new submission, and I will say we've already received a submission, but it's incomplete because there's no plans. But we've already received an application submittal for the same parcel of land.
got all the
No.
questions in my sub
Yeah,
part.
there's no waiting period. I think I brought this up before for subdivision applications, as there is for rezoning decisions.
Any other comments or updates right now? Is there anyone in the public that would like to make a comment before the board moves on to its business?
I don't have any signed up. I don't know if Patty has any, Michael, any but online.
Okay. Thank you. Well, we appreciate you're here to participate through listening today. Old business, we don't have any, so now we can move on to our new business. And Michael, will you be introducing our attorney?
Yeah. So Mr. Mac McKellar's here. Mac has traditionally served as the Board of Adjustments legal counsel during quasi judicial proceedings for variances, special use permits. Obviously, we heard some feedback from the planning board and also in the budget discussions where the planning board chair attended that the planning board would like to have some legal counsel available as needed at specific meetings. Mr. McKellar's agreed to serve in that capacity. And so I just wanted to give him the opportunity to be here before you, introduce himself. And if y'all have any questions for him off the bat, he's able to answer those for you.
Yeah, good evening. I am Mac McKellar. I'm from over in Brevard. I'm the city attorney for Brevard. I've been doing that for about 4 years. Prior to that, I was district court judge here in the judicial district with Henderson, Transylvania, and Polk counties. And then prior to that, I practiced law, just general law in over in Brevard. I'm very familiar with Mills River. I remember when Mills River was founded, as a matter of fact. And I've been watching with great interest. I think it's I'm very involved. About half my practice is as Brevard city attorney, which is why Sharon Alexander, who's the town of Mills River's regular attorney, asked me to come over here. It's generally considered a good idea to have a different attorney for bodies such as the planning board and the Board of Adjustment than for the city. Technically, there have been occasions, in fact, we just recently, city of Brevard had to sue our Board of Adjustment, which was awkward because the chairman of the Board of Adjustment is my son-in-law. But it's another story. But nonetheless, and so when Michael said y'all were interested in making sure that you stuck to the law and did what you were required to do and what you wanted to do, I was happy to come over, and I'll be glad to answer any questions if you have any now, or my intention is to stick around for the whole meeting. So I got a feeling HB 765 has been on my mind a lot too.
Yeah.
So that'll be an interesting conversation. But nonetheless, if you have any questions, I'm more than happy to answer them. Otherwise, I'm just going to sit here. And the general rule is I should not have to say a word in the entire process because y'all know what you're doing. You've been doing it for a while.
Right.
Okay.
Thank you.
I have one general question. How does it work with the attorney-client privilege at a public meeting?
It, if there is any items of attorney-client privilege that need to be discussed, you'll call a closed session,
Okay,
which you can do.
I'm not saying that there is any,
Right.
but it just.
Right,
the-
but that's the way it works. You would
Okay.
call a closed session, go into closed session, you'd empty the room, all the microphones and things would be turned off. You're only allowed in North Carolina to call a closed session, for very specific reasons. Personnel or legal advice from an attorney to their client, which would be from me to you.
Thank you. That's helpful to know. Again, not something that we anticipate or hopefully shouldn't need to trigger, but it's just nice to know how you would handle that logistically. Okay, great. Well, I do think we probably will have some questions that maybe come up in the context of the Mills River discussion, which may be moot for
And
now.
And I'm gonna suggest, I guess it's my first act, that given that there's no application
Mhm.
before the board,
Mhm.
it might be unwise to get too deep into specifics
Right,
until you see what the plan is.
right.
You wouldn't want there to be any suggestion that anything has been prejudged in that.
Sure.
So I
sure.
would encourage you
Yeah.
not to get deep in the weeds on that.
Okay, that's super helpful. That's super helpful. So I think next we have another person to introduce.
Yeah, so Mr. Rusty Darnell made himself available tonight. He is the Assistant District Engineer for Division 14, District 1, works just down the road at the DOT offices there. Again, with the North Carolina Department of Transportation, and Rusty's made himself available to be here tonight and just introduce himself and answer any questions from the board.
Great.
Good evening. I'm from Henderson County, born and raised in Mountain Home. I've got 30 years with the state. My sole purpose as the assistant district engineer is to do what I can with the development that we're getting in all three of our counties to ensure the integrity of our state road system. Sometimes that works with planning boards and technical review committees, and sometimes it's at odds with them. But we try to always find something that's workable. Anytime y'all got a question, like you said, my office is just around the corner. Feel free to reach out. I'm available. I can come meet with y'all. Whatever I can do to help out, I'll be glad to.
Thank you so
Thank
much.
you.
Thank you. We really appreciate that. Okay, so now turning to questions or discussion about the Mills River Crossing subdivision. I'll turn it to Brian to start, since that was your agenda item.
Sure. As our attorneys just said, not to get into specifics of a prior permit, that's not one of my bullet points here. There are some other things, and some of them are really high level. Do we even have a role in those things? A couple of questions. One, obviously, we all know that permit was taken back, but they have reapplied was one of my questions. It's incomplete, so we don't have anything specific, but can I ask that, is that the phase 4?
Yes, it's that same property.
So that was gonna be one of my questions. Separate from that, we still have the storage facility permit.
Yeah, there's still a zoning permit on file for a self-storage facility on the 35-acre parcel adjacent to Mills River Crossing South.
Okay, so that, again, separate. Perfect. Where is the town on that walking trails conversation? Anything different from our last meeting?
The walking trail or the pedestrian facilities for the subdivision is now moot. Since the application's been withdrawn, there's no expansion of the Mills River Crossing subdivision over 100 lots.
Right, so for now.
So for now, the requirement's not been triggered unless Mills River Crossing's proposed to be expanded above 100 lots.
How many developed lots are there right now? Or undeveloped for that matter, sorry.
I don't know off the top of
Under
my head.
100.
Yes,
And
it would
100 is the
be between 90 and 95.
So the trigger is 100. So one of the questions I have, and I know you weren't here at the beginning of this, but maybe you were here when this decision was made. And this isn't meant to grill you. I'm trying to give them information so we can talk intelligently to this. At what point did the town hit the trigger in their minds, this sidewalk conversation that came up? It was in front of the Board of Adjustment a while back, right?
I was the one that made that determination. It was when Big Hills Construction submitted the first Mills River Crossing Phase 4 application, which I believe was in either summer or fall of 21. So it was first submitted in 21, was denied due to not meeting the pedestrian facilities requirement and some others, and then reapplied in 22, which was the application that was before the board at the last meeting.
Okay. And again, just trying to get history on this. So we're speaking as intelligently. You weren't here when the first, phase began. I don't think anyone except for Mr. Foster was on this particular board at that time. So we're just trying to get a history on that. One of the reasons to the board I'm asking this question is, and full disclosure, multiple people sitting up here, including me, for different professions that we are in, have clients who live in Mills River Crossing. If that's a problem, please let me know. I'm not here representing them in any way. But I have my years of owning real estate firms sold in that neighborhood. Don't have any inside information for anybody, just a matter of disclosing. One of the reasons I'm asking this question is there's a lot of anger over there about these trails. And just to clarify, Mr. Malachek, the town, and in this case, I'm not putting you on the spot, but again, just to clarify, you're the one that said, hey, as an alternative, maybe we look at putting the walking trail off-site.
The developer met with us and was looking for a path forward to the development. And when we met together, noting that there were no standards for a walking trail versus standards for a sidewalk, they decided to explore that option.
The off-site being,
Yeah, well, that was the only land that they had available to do that.
Right,
My
right.
understanding is.
one of the things I come back to, and this is just, we all provide a different experience here. My experience is in real estate, and I see this, and I struggle with this north, if everyone knows what I'm referring to, Mills River Crossing North, Mills River Crossing South, being considered a single subdivision and triggering this 100 homes to begin with. There's a 5-lane highway between the two. I get it. It was all one parcel at one point, but what wasn't one parcel? If we go back far enough, where does that stop? I'm actually, and I'm not a Big Hills, representative in any way, and I actually am on record speaking against them quite aggressively. But I think I'm on their side. I think this might be in their favor. My suggestion that do we as a planning board, again, the big question in the front of this is, do we even have a role in this conversation? Should we even be enforcing this path, these walkways? When I don't see the 100 home even being triggered here, I don't. I'm not getting into the weeds of, hey, we're taking other property and starting a walking trail onto other property, and we have private people leaving the private neighborhood and public people entering the private neighborhood. I'm not even getting into all of that, which I think is asinine, by the way. But not getting into it further than that, I wonder that the town even is right in this. Are we really right in forcing them to have the sidewalk, or in lieu of sidewalks, walking trails? If, and I get that, it's moot right now, but that's coming. They're going to try to go over that, and we're going to be back here having this conversation. Again, I'm not talking about that permit. I'm talking about the validity of even enforcing these trails to begin with, and maybe we don't have a role in this conversation as a planning board.
What determined, where is how is it decided that it is one subdivision versus two? Where does that come into play?
The definition of a subdivision and the naming and the specific application materials submitted by the applicant all indicated it was Mills River Crossing Phase.
You mean
So on and
they're,
so
so
forth.
when they initially purchased the 2 parcels, or what was 1 parcel, but was split by the highway, when they initially purchased those lands and made the initial application for subdivision. In their view, at that time, those were kind of all considered a single subdivision of Mills River Crossing.
They
I
have a
don't-
declaration.
I don't know what they decided,
Oh,
or
okay.
felt then,
Yeah.
but the original application was for Mills River Crossing Phase 1, which was just like 6 to 8 homes on one cul-de-sac. And then they came back for Phase 2, which was the rest of Mills River Crossing North as we see it today. And then before I got here was when Phase 3 was submitted. So again, you see Phase 1, Phase 2, Phase 3. And again, it fits, it becomes legalese. It fits the legal definition of subdivision. So in interpreting the ordinance, while they're separated by streets, and obviously we found out later, separate HOAs, legally per the code, it met the definition. But obviously that's an interpretation that can be argued.
Is there, so right now, we've been operating under an interpretation of the code, which may not. We've interpreted the code to say that they are based on the fact that the subdivision applications have been phases of the same initial, that like is.
That's,
phase-
yeah, that's one part of it, but
Right.
that's correct. I mean, when
Yeah.
they're calling
There's
it
a
one,
general,
yeah.
portion of the ordinance which says that there shall not be phasing so as to avoid any of the language of this ordinance. And I think that's where the interpretation comes in, is that by using the same name under that ordinance,
Right,
the statement is, well, if this appears to be utilization of multiple phases to attempt to avoid something in the ordinance. I believe, isn't that what
Yeah.
you're referring to,
and
Michael?
just to build on that,
yeah,
every subdivision requires a certificate of understanding to be signed by the property owner or the subdivider that states that if the subdivision's expanded, you agree to comply with any other provisions that come into play. And that was one of the town's primary arguments is Big Hill signed on the dotted line that if they went over, they may have not looked at this exact provision, but if they expanded, any and all parts of the subdivision ordinance would apply. And so that's also why they were held to that.
right, I understand. So it sounds like, the interpretation of the subdivision ordinances is actually designed to make something something that is logically all being done by the same developer under the same name. To ensure that if they keep adding phases, that they can't skirt the ordinance, they can't avoid an ordinance.
That is the upshot of this.
Yeah.
Now, what this particular, I mean, I read through all this stuff before I knew they were calling it off. And so the upshot of this particular application, if the next one approximates what this one did.
Yeah.
The question is going to be if there's two separate property owners associated, is whether it is two subdivisions or whether it's one. And that would be a decision that would come under your purview in approving compliance with the subdivision, which is your role in this, which is does this subdivision plan comply with the subdivision ordinance of the town of Mills River?
So the follow-up question I have written down here was, would the HOA, the separate HOAs drive that? They're clearly internally considering themselves separate.
That would really be the decision to be made in the wisdom of the board,
Mhm.
and would be subject to the specifics.
Okay.
And again, right now it's moot because we're under the
Right.
threshold. But as soon as we go over it, does that come to this board? That new at the time. This isn't the old permit, right? The old one that they've been like, from what was that, 5 years ago? That one's gone.
Yeah.
So if they do a new one, it would come back here, right?
Yeah.
Okay.
So they could skirt that. They could make that a separate subdivision with different access if they wanted to and not trigger the 100. There's things they could do, but I'm not getting into that. If it comes to us, that is the planning board's purview is what
The,
you're,
the planning board's purview is to review the ordinance and what the requirements for a subdivision are, and to certify, essentially to certify that those are being complied with. And one of them, one of the sections would be, is there a requirement for sidewalks or is there not? And it really depends on how it's dealt with structural.
well, one of the
Um,
great things we learned from, and Michael, please remind me, our UDO member, what's his name? I'm sorry.
Gotcha.
Chad,
Jeff. Thank you. Was that the board has the ability to give a lot of weight to public interest. Those are like some of my favorite words I ever learned sitting up here. So I think for me, that's enough on the trail conversation until it comes back to us, if that's okay, unless someone else wants to add. It's not that I don't have other things to talk
and I
about.
guess the question for Mike or Mac is that, you know, it would be our purview if those HOA were created separately to skirt or to avoid the 100 homes in one development.
That would be our
Yeah, so I'm
It
saying.
would,
conversation.
it put, that would be, if that were to happen, because
Right.
we're really talking in speculation and no knowledge at all, because there's been no
Right,
application,
understood.
filed. But yeah, that would be your, determination. And yes, while public interest is a big factor, you also have to weigh that against, property rights.
Right, right.
And so that's what you're doing on this board.
Yeah, just as an example of what he just said, you guys may not know this, I dug down into it again. I had a client came over to my house and we had a conversation, Sunday. HOAs, you might ask, why don't they have HOAs already? Well, go back into the declaration and the developer set it up that way, where there was a trigger that was much later than a traditional subdivision would be of 30 or 50 or 60%. It was much further into the process. And then it had a date that followed that. So they're just getting there. Some people are interpreting a fourth phase, setting them back on developing, or I'm sorry, initiating the HOAs. So they need to hire their own attorney, have that conversation.
That's, yes. And I
That's
think,
not us.
I having reviewed the records, they've certainly got one. And you will hear from them
Perfect,
if this application is completed.
perfect. If I can't keep going on this,
I-
I'm done with the trails, but I still have something on this one.
I have a walking trail question. Mike, and that goes to the ordinances, and that is, so in this case, again, well, in the permit that was before us, the walking trail was proposed to be, well, so obviously the first is there's a choice between sidewalks or walking trail. And just due to the dynamics of the way that the subdivision is currently built and those trying to retroactively put in sidewalks, that wasn't that wasn't really like a reasonable option. So if this is triggered, the option that gets triggered is the walking trail option. My question is, so their proposal was to put the walking trail on land that they owned that was adjacent to one of the existing subdivisions.
That the developer owned, not the HOA.
Yeah, sorry, that's what I mean. So the developer's proposal was to put the walking trail on land that it owned that happened to be proximate, adjacent to the subdivision, or one of the half of the subdivision. My question is whether anything in the ordinance allows for reasonable interpretation that the walking trail either needs to be within the subdivision, whether it can be on land that's adjacent to the subdivision, or whether the walking trail could be, say, instead of building up, because there isn't enough space for them to do it in the existing subdivision. There isn't a reasonable basis to put a walking trail around a storage facility or whatever happens on their adjacent land. So that land sort of goes off the table. Can they offer a walking trail someplace else, someplace not within the subdivision? Or could they say, fund a walking trail in a public park.
You speaking of something roughly akin to a fee in lieu?
Yes.
And frankly, I did not look at that section of the ordinance, so I can't answer that. Michael may have a better.
Yeah, the town does not have a fee in lieu program, but that's something legally we are allowed to do. That if a developer cannot meet the requirement for a recreational amenity, they can pay a fee in lieu of providing that amenity. And that money would have to be devoted to something of a recreational nature, most likely the park.
Yeah, so, I mean, again, this is all hypothetical because it's not currently in front of us, but.
And it's not in an ordinance either.
And it's not.
Unless it's allowed, unless it was in the Mills River ordinance, it can't be done.
So-
It has to be,
it's
it has
not
to
a-
be allowed in the ordinance and it's not in it currently.
Okay. So in order to make that would be something that we could do a text amendment?
Yeah, we'd have to establish it in the subdivision ordinance.
So
Nick,
fees
what-
in lieu are not there today, but can I go back to the first part of Lisa's question is the ordinance
Yes.
dictating that it be within?
No,
Okay, so could
No.
that be something that the planning board proposes? I'm not a fan of fees in lieu. The good old boy stuff gets out of control sometimes. It would need a long conversation, but quickly, could we quickly, while the old permit is no longer held to the old standard like it was before?
When they-
Anyone or anyone puts in anything today, it's held to today.
when they submit a complete application, which is the determination of
Right.
staff, they're allowed to develop under the rules in place at that time. So if they upload site plans tomorrow, they can develop under what's in place now.
Right. I'm not trying to race
Yeah.
them to this.
Can I-
I'm just trying to say that we could, in theory, get something quicker of a limit within the property. One of the big complaints from the public that was here was this is leaving our property, going somewhere else.
Understood, but I think also one of the complaints was, well, one, that they didn't want to have a connection between the subdivision and this other property, and that having a walking trail around another structure, which was intended to be potentially a storage facility, you know, that it was sort of like, okay, we're meeting the statute or the ordinance, but in a way that makes no one happy.
If I'm a resident there and the town gets a fee in lieu of performance, I want that money.
Yeah.
If I'm a resident of that neighborhood, I don't want the town to put a butterfly bush over there. It came from the developer who made money off the purchase of my home, and I don't want that money going somewhere else. You see that fundamentally where fees in lieu it's a rabbit hole. I'm not a big
Totally.
fan of.
Let
Yeah,
me jump
go
in
ahead.
here for a
Please.
second,
Please.
because this is the conversation I had with Michael. Because in the general ordinance, it says that the provisions need to be within or related to. Now, this is what I emailed Miss Lisa about, and which is part of E. Is to actually remove the related to get that text amendment out as quick as possible. Brian.
Great.
So that the provisions of the ordinances, set for, our subdivisions have to be within them. I'm sure that we could still, add the in lieu part. Because if they run out of property, and their HOA decides that they do want to fund something like that, in development with their, contractors, you know, hey, that's okay too. But I did not like, just a private parcel being utilized to expand a subdivision. That sets a bad precedent, forward. So I think if we remove the related to and require all the provisions to be within, I think that will help us move forward and not having this situation at least pop up in front of us again.
So you've got that in your E.
Yes.
So
I'm
I'm
we're
good
gonna
with
talk about
trails
it.
on that.
All right.
I still have one more question on this. I'm sorry.
No, that's okay.
Look, public interest, I just keep going back to public interest, and we begged for years for the public to show up. They showed up at the last meeting with interest. And, without trying to, be their representative in any way, I have struggled from the start with what I'm getting ready to say, because I have had clients purchase in that subdivision and other subdivisions. The UDO gives, everyone knows what's going on with the UDO, right? Regardless of downzoning or 765 or any of this, it's moving forward as planned, and we're spending a significant amount of money on it. We have, stakeholders identified in there. Again, I'm not personally attacking anybody over at Big Hills. Public knowledge that Big Hills, I believe, Michael, unless this has changed, is identified as a stakeholder for the town of Mills River in developing its UDO. They're not on our list of stakeholder. Were they on it early on? Okay. Awesome. My apologies. I thought that they were identified.
There was a Mills River Crossing resident that was a stakeholder, and there was a Mills River Crossing adjacent landowner who was a native that was on the stakeholder list.
Perfect. Okay. Do we have any other developers? Moore and Sons, are they a stakeholder?
Yes, that's and I'll just remind you, the board, the idea of the stakeholder interviews was to get feedback from the entire community, including developers, because we need feedback from folks that deal with our development regulations. Not saying we're just listening to them, but that's the reason to include someone like Morris.
Right. No, you don't want all the information coming from one, experience. I totally agree with that. Okay, so on that, the last question here, I can't even remember why I wrote it down before. Was there a variance applied for in that last permit, Mike?
I think this might be a little bit
Too far?
too far.
Okay.
Just wait to hear what is presented to you before it appears you're making recommendations or decisions.
Okay.
And instead of recommending procedures that the applicant could potentially follow.
Okay. Appreciate the advice.
Yes, sir.
That's all I have. Thanks for letting me at it.
Land Preservation Committee appointments. Is this something? I don't know.
Oh, yes, this is correct. So staff has been working behind the scenes on the land preservation program, getting that moving forward. Oh, my staff. So you can see the background. Town council formed the steering committee in May of 23. Over that year, the steering committee developed the land preservation program, which was adopted. And then as a final step in March of 14, council adopted the charters and rules of procedure for the land preservation committee, again, the body that would make recommendations on land preservation applications and funding to council, but then the town manager left for another position and we got off track. So now we're trying to get back on track with that and have council actually appoint members to that board with the goal of rolling out applications this summer and getting into a funding cycle before the next budget year. So we brought this to council at the last meeting and then basically asked for the boards to discuss and no formal nominations, but basically put forth names of those who are willing to serve, have the time to serve, and are interested. And then I will take those names back to council and they will make appointments from that list.
That's excellent. Myself, Jim, Brian, we're all on that land preservation committee. So I'm really excited to see it kind of rolling out and taking shape in this way. Please go right ahead.
In a council meeting, I understand. You continue to say you want.
No, we are, what Michael said is that we are seeing who is available and interested and sitting.
I was supposed to be volunteer.
Yes. I think that's the question, is whether anyone,
Give Michael take back.
Yeah.
Correct.
Who was interested.
Yes.
Who's interested?
yeah, interested and available so that they can they can make those appointments from that pool of potential nominees.
There would be one appointing, but we could send back two agreement.
Sure, yeah. Yeah, so it sounds like that's, something, if anyone wants to comment on now, about that, or if you probably could just reach out to Michael. Let him know.
Can you scroll up just a little bit or down, whatever, down, be down. Sorry.
Yeah.
Oh, sorry.
If it's easier for you. So we're looking to see if anyone is interested and available to serve on the Land Preservation Committee, which will be using the criteria to evaluate any applications. So this is a pool of money that the town has to help preserve farmland within the town and to help our residents who want to who have large tracts of land that would rather see them be put into a preservation, put them into conservation or preservation easement instead of developing them. So giving them-
You know, I'm interested, I'm willing, I'm available, but I also want to make sure everyone else has opportunities, because this is something that's
I'm-
should be important. I believe it's important to all of us here.
I wholly agree with you. I do not have the time to commit to this right now, so I would not put my name in the hat, but I would love to do so. I think this is a really, really great opportunity.
Please throw mine in there, but understand that you guys know I volunteer for so much of it that there's been, spread it out. If someone else is interested, stick them in front.
Okay, well, we'll think about it.
There
I
you go.
bet Lonnie is super interested. We could put his name in.
I
mean, you can put my
volunteer, if
name
you're
in
gonna be
mine.
sick, you got.
Yeah, put my name in there as well. Can I nominate somebody from the public? Or add a name, or can I have it submitted to you, or have them submit? to you,
Yeah, so,
Sarah?
there is an at-large application, for a town resident available to sit on the Land Preservation Advisory Board, and that's available on our town website.
Okay.
We also did a Facebook post, I believe, pushing that out, in a news flash last week.
And for the members of the public that are here listening, my volunteering on the Land Preservation Committee is what eventually landed me here on this board and now here in the chair position. So, I highly encourage our members of the public who, have interest in any issue relating to the direction and development within the town, it's what it takes, is it takes us kind of showing up for these kind of committees and, we'd love to have you. We don't need to have Brian on all the committees, so.
You don't want
Um,
long, loud meetings.
It's a great opportunity to kind of get involved and this is, once a quarter. So, it's a great way to kind of get started and experience what it's like to be a member of one of our town boards. Give you my pitch for. Right?
Yes.
Right? And so then you can just stroll right in to the planning board meeting right afterwards. Okay, great. Let's talk about our future land use map amendments.
Okay, so you may remember the discussion of this when we did the comprehensive plan amendment, TXT 2501. That's where the planning board recommended to remove industrial uses from the community center future land use district. And we had a discussion that there may need to be a future land use map amendment at the same time. And specifically, we talked about possibly accommodating industrial uses in the Schoolhouse Road area, since a lot of that land is already zoned light industrial, but some of it isn't. And then also the extent or how far out the community center district goes. I think in that example, we talked about it going out between Old Turnpike and Kinsey to the west, and if that was necessary. So staff brought this to the attention of council at their last meeting on April 24th. They did approve that comprehensive plan amendment, so the comp plan is now amended with no industrial industrial uses. Or industrial uses being undesirable in the community center district. But council wanted to initiate this future land use amendment. So basically you brought this back, to you tonight, just again, that is why this draw a draft map, doing which areas the planning board wants to look at. We thought we would have to discuss and look at the future land use map and kind of scroll through GIS to get some preliminary feedback from the planning board and give direction to the staff. And then we can come back to the next meeting with a preliminary draft future land use map for y'all to react to. So in your attachments, you have the future land use map, as amended last year. Again, you can see in this one, the different green color where we removed, the commercial crossroads district on the Ray Hill intersection where we added a little bit of commercial crossroads, near Gash Road, Hunters Ridge intersection, of Boylston Highway. But today, put my mouse on, today we're going to be specifically looking again at the red area here around Schoolhouse Road, and then again, how far out this red community center district goes. Again, we started about looking at it going past Old Turnpike here. I think it also warrants some discussion up here because it's assigned to some long existing residential neighborhoods that may not be appropriate. But that's the future land use map. And then just so we have all the district descriptions and everything else, the other, I mentioned comp plan documents are in your packet. The district descriptions is attached to B. The amended future land use district chart is attached in C. And then I did include again that in attachment D, the public input from the comprehensive plan that I brought up briefly during the comprehensive plan amendment, showing, in input from 2019, 2020, where residents desired some, or thought it's acceptable for some future land uses, with the red dots on this being industrial.
But attachment C, what was the language change there? Chart.
There was actually no change to that. Remember, community center already had industrial not desirable. So sorry, that one is amended from last year when we changed it to rural agricultural versus rural residential future land use district. It's actually just attachment B that we amended in the last amendment. Striking out industrial from community center.
You go to the future land use.
So we're looking to see where we can both recommend cleaning up the community center, which is red, and potentially expanding the industrial and employment, which is blue.
Yeah.
Is that correct?
So again, industrial and employment right now really only exists around our industrial park. So we've got the Ferncliff Industrial Park where Sierra Nevada, Linamar Light Metals is up there, FedEx facility. And then we've got the industrial future land use designation around Broad Point Industrial Park in those intersections. What we had talked about is that if we were removing industrial uses from the community center district, obviously we've got some industrial uses like Morrison is here, the Lowe's warehouse is up here, Mills Brewery technically because its beverage production is industrial. Same as Bull Rock, that's technically beverage manufacturing, which is industrial. This parcel is already zoned light industrial. This parcel here is not zoned light industrial. I believe it's neighborhood commercial currently, but I know that's been a target for potential industrial development by the Partnership for Economic Development for Henderson County. And then
So is greenhouse considered ag or?
Well, greenhouse is technically agriculture, but I mean, I think that's something for the board to consider is that if future land uses there should be either, if it should stay community center or if we should consider that industrial and employment. Now, just because it's a greenhouse and it's a bona fide farm use, it's still exempt from zoning, but that doesn't also mean it's not a manufacturing use that employs folks.
Although agriculture is an acceptable use in the community center. Um, so even though it's exempt from zoning, it would still be, kosher with I mean, it would still be acceptable under community center. A greenhouse space.
So Michael, with the industrial that's inside the current community center, just for the next map, can we change those colors around?
Yeah, we can do that.
Awesome.
Is the board okay with that?
Yeah.
Because I think that'll give us a better idea. And also something that at least I'm taking into consideration is the floodplain. I know that the two under that triangle of between Schoolhouse, Haywood and Banner Farm. So on the lower part of that, yes.
Down here.
Yes, so towards that smaller edge of that triangle on the right, those are in the floodplain. I was looking on the GIS. So
That's my house.
I told you we were talking about where you live today. So so I don't, is there a way that we can also mark our floodplain easily for y'all? I don't want to praise this thing, but I would like to see, like, I don't want like high density development in there because that's a lot of people that's going to be flooded. So to take a little bit more depth into what we are also trying to protect, the floodplain, what we should really leave as open space or agriculture so that it can get flooded and we don't have to really worry about as much loss of life or higher prices with destruction and damage when it comes to a plant.
Here or when we get kicked something,
Which conversation, sorry?
allowing X use and flood. I mean, we're not there right now.
No,
We're loving the
But I
downtown.
just need I would like to see an idea. If we're gonna change the map to kind of like look forward the next 20 years, say, we know that that's a possibility. So try to keep that in mind as we move forward.
Yeah, I'm not sure if I want this particular map, the future land use map, not a zoning map.
Correct.
I'm not sure I want it marked up with that, just to drive our questions when we're considering something.
But I don't want to put industry in a floodplain either.
I get that, but if you, Mark Boylston, I mean, we have, what did we say, 13% of the town is in flood?
15% of all of North River is in some type of flood.
Sometimes, so
Yeah.
we're going to lose a lot of visual here. A lot of development is around water, but we're gonna lose a lot of the visual of this, the future land use map.
Yep.
Along with comprehensive plan, driving our decisions, our questions. I'm not sure I want this particular map marked up with too much color.
How about this, Michael? Could you do it for me?
I mean, we can
Here.
also pull up GIS.
GIS is a public site that has your
Well,
floodway, your
that's
plans.
that's where I was
Fine.
looking earlier. And was recognizing that a lot of this property is in floodplain. But when you pull out, when you're looking at larger swaths of like where we're gonna put community center, where we're gonna put industrial, like where we're wrapping our minds around it, it's easier for me to say, well, maybe we could shave off here and move a little bit more to the east or the west or the north or south.
Yeah, I would say unfortunately, you're gonna have to incorporate 3 maps. One interactive, which we're in right now. One with our guiding tool.
Mhm.
And then the third is the zoning map, which is none of this.
Correct. Correct.
You just can't overlay all. It's too much. I think this is.
Well, with the
pub-
zone, so I'm not taking into account much of the zoning map because it's all mixed use anyway.
Yeah, it's got a lot more. In the areas we're talking about.
Yeah.
Like commercial, or neighborhood commercial.
Well, we can't,
Got-
but we
So-
can't do anything about the zoning part.
Yeah.
right
the
now.
Future land use map isn't going to be put on hold while we're having these other conversations.
Correct.
So I'm not sure I want, I mean, feel free to chime in here. I'm not sure I want this chopped up too much. This is to present to the public that, hey, we understand you're telling us where you want us to drive this thing. Simple for them.
Yeah, I think the first step, because I think those are words you used, Michael, would be just to do what you recommended, which is take what's already industrial in the red and color that blue. That gives us a really quick visual there
Yep.
to expand on that.
That's existing use.
Right, yeah.
And then you also wanted us to look at the top part.
Yeah, so let me switch screens. So the other thing I just wanted to bring up while we're looking at the map is the extent of community center, so the red. So again, community center being the center of the town where we want to encourage a mix of uses except for industrial.
Yep.
And the question came up, do we want that on the west side of Old Turnpike Road? This up here is also a watershed critical area because the city of Hendersonville drinking water intake is right here. So anywhere a half mile upstream, I'm drawing kind of an approximate circle, is where no type of high density development will be allowed because of the stormwater triggers.
Within how far, by the way?
Half a mile radius of the drinking water.
So it's half mile radius, not a perpendicular to it, a half mile upstream.
Correct, half mile up the drainage basin.
Okay, okay. So they can't, there's too much impervious ground needed there to do, they would never get permitted in.
Well, then we'd have to figure that out through the
Right.
application process, but I'm just stating, community center again, from the category is to promote a mix of uses including commercial, residential, ag. And residential can be multifamily. Do we want to encourage that in the watershed critical area, or do we want to encourage that in an area on the west side of Old Turnpike Road, which when I've driven out there seems relatively rural and pass over. But again, just bringing that up for discussion. And we are looking again, 10, 20 years into the future. Again, this map is in the comp plan or advisory documents to inform future zoning decisions.
Yeah, I mean, I would remove it west of Old Turnpike
I
Road.
agree. The first V you come to up Old Turnpike is the back, right?
Right.
And then the end is all watershed and of course, the mountain does disappear. Right?
Definitely, yes.
The north.
The
right?
filter site, yeah.
Yeah, so that's how I said what we got. Yeah, mountain, and then Schoolhouse is a great natural line, Old Turnpike. What about where you're at right there is heavily flood, obviously it's being filled in, so kind of forward.
Do you want to transition up here?
Yeah, I'm asking if there's if the board thinks there needs to be any consideration to a connection there. And we have
Oh.
RD, we have the town hall, right?
No, that's,
Hardy is on this site and they are only probably right where my mouse cursor is because everything south of that is flood.
Yep.
So again, we don't have floodplain regulations, so you can still build floodplain, but because we don't have floodplain insurance, those buildings are uninsured, so they're not gonna build.
Unless they fill, like the town hall, right?
Well, no, because you could, if you fill, I mean, you'd have to go through FEMA and get a letter of map revision to get yourself legally out of the floodplain on the maps, because your insurance is gonna look at the FEMA maps and basically state, oh, you're in a floodplain, you need flood insurance, even though you've raised it 4 feet, it's not
Correct.
reflected in the regular.
I will tell you the way out of that is an elevation survey.
Yeah, or letter of map revision, yeah.
Well, an elevation survey will get you out if we have flood neighborhoods. I'll use something outside of river. Past elevation surveys. You have a whole edge of a neighborhood that's built in it, but it's only the crawl space. So, right, so, or it's only the storage shed in the back. So, anyway, you can get elevation surveys. To get that. With or without FEMA, we are not FEMA. Eligible. So I guess my question was more general than that, was more generic. So do we want to consider making multiple community centers? Or are you looking at connecting? I'm not looking, I know you're not driving something specific. Is that one of the things you're picturing is connecting them or?
No. honestly was looking at pulling back. So
Mhm.
one thing I'll point out is this subdivision right here. You know, this is a residential subdivision that's been here over 20 years, I believe. I don't believe these single family homes will ever be converted into a community center type development. Yellow is the mixed residential future land use designation. So again, I'll just give you my input. It would make much more sense for an existing subdivision to be in a residential future land use category, not in the community center. So another area I would just target for y'all to look at would be this area up here,
Right.
where along the edges, it's primarily residential that's been there quite a while.
Yeah, and I think that makes sense. I had a specific request from a resident of that type, not that particular one, but type of community where there were commercial enterprises built on their back door, so to speak. And so, yeah, I would pull that red away from any existing housing development. Because in this particular case, there wasn't a lighting ordinance when this commercial building was built, and it backs up to a neighborhood. And so you can see that encroaches upon them. So yeah, anywhere in the red where there, if you would identify it, not at the moment, but if we could identify where there were residential neighborhoods, we would want to pull the red away from that, I think.
Their general consensus already.
What's in the center of that one where you just were to the left of your cursor? What are those 3 or 4 large parcels?
Over here,
Yeah. Existing use right
one of them is the self-storage development, and then the other are all owned by the church here. Grace.
All those parcels are owned by the church.
Not this one, this is privately owned. But these 3 down here are the church. This one is Summit Storage, and then that's private.
So you're almost talking a horseshoe around the top of that field there.
Yeah, I mean, usually vacant land, I would probably leave that in the community center district, but again, it's these single family parcels that are in it that I just don't think it's necessary. And then again, I believe it also expands up into this area, which again, that'd be the planning board's decision whether the designation should go up that.
And back to your future land use map, sorry, that's mixed residential. That's the nearest adjacent there you go. So that is mixed residential.
Well, everything on the south of Butler Bridge that we were just looking at is community center, but
No,
everything around it
right.
is mixed residential.
So my horseshoe description doesn't look like a horseshoe when we apply that because the yellow actually creeps out. Let's just say west and then south. And then to the south, the southeast over there as well.
And there is,
Probably colorful.
I'd be in favor of increasing the mixed residential in that area that we just discussed surrounding the storage, some storage and the church properties and the vacant field privately owned up there.
It's their general consensus with that bunch of and the draft.
I agree.
I wasn't really planning to dig into the community center district here, but again, we can look at that. Some of these larger parcels here are just full of residential properties with large fields. So again, you can see the community center includes larger parcels like these, but again, currently being used for sale. But again, I have no specific recommendations about that. I was mainly concerned with the larger tax. They are not. They are actually this little sliver right here in mixed residential. Yeah, they are right.
So we can move that.
Is that not already under mixed residential? Neighborhood oriented uses?
Schools are in both community center and mixed residential, so either.
I'm fine with where,
either is
what that's
fine.
worth.
I agree.
And then really the only other thing I was gonna call out, since we were looking at industrial and employment, there are some parcels here in Broad Point. My understanding is when the comp plan was drafted, and the future land use map put in place, any property that had any amount of floodplain touching it was given the green designation or the rural agricultural future land use currently. But there's a warehouse on this property right now, so would the board be okay if there's an existing light industrial use there to change that on this map?
I agree. I think as a general principle, and sort of putting this idea out there, but changing the future land use vision, at least as a starting point, making it consistent with its current use is helpful to help us consider, how we would expect it to be used in the future, right? So I mean, as a general principle, I think that would be a super helpful thing to see, like you said, in draft, places where neighborhoods should be adjusted, their color should be adjusted to mixed residential, or like you said, areas that are being used as industrial, seeing those in blue would be useful to see. I think as a general starting point, to kind of make an informed proposal about how to amend the map overall. Kind of just completely in line with what you were suggesting, but I think if there's other areas where you're aware of some kind of inconsistency with the current land use vision and
It's current use.
its current use, we could maybe kind of see if there's any other, those are probably the big ones that you've already pointed out, but that might be a good thing.
Especially that scenario, if I understood correctly, it was
Yeah.
vacant when the future land use map and comp plan were put together, but zoning allowed for a warehouse, but now it's a warehouse.
It's,
So that,
Yeah.
we had hopes of preserving it back then, but we missed that.
So I know our focus is on the north and the central aspect of Mills River. Can we also apply those to the southern district?
Why would this?
The same rules, like if there's commercial or industrial, I don't think we have any industrial along the lower or the,
Right now, it's all rural agricultural, except the commercial prospects. And I would advise that if we're gonna make those type of changes, we maybe save that for another future land use map amendment, since council initiated this one specifically for community center and
Yeah.
industrial. We don't wanna stray too far away
Yeah.
from that.
Gotcha.
Because if we get to a public hearing, we'd have to change the notes.
Well, and based on our zone that was approved but not applied, I wouldn't want to mess with that either.
okay,
Well, that's great feedback, and I'll
Thank you.
draft that up for the next meeting. for
That's-
consideration.
that's great.
Thank
I appreciate that. Moving on to down zoning. Is there an update on where that stands, Michael?
So what I had tonight, and I think we're combining this conversation with House Bill 765 as well.
Especially. if
Yeah,
you're
we're
ready
gonna,
to-
I'm sitting here, they just did a committee substitute today on H Bill 765, so it doesn't change the downzoning repeal, bad choice of words.
Correct.
Yeah.
So
57.
I will say that, council requested an agenda item at their last meeting for this Thursday's meeting for a full update of all potential state land use bills that could affect the town. And so there will be a much more comprehensive view of everything this Thursday. This is a shortened version of that, specifically looking at down zoning and specifically looking at House Bill 765, the local government development regulations omnibus. So right now, related to the downzoning, we have House Bill 24 in play. This is a statewide repeal of prohibition of local government downzoning, or the session law that was enacted. This has sat relatively dormant until yesterday. There was some action assigning it to committees. Again, that's not a guarantee it's going to move forward. Legislative crossover is the deadline, which is May 8th. That's also this Thursday, when bills should be making it to the other chambers, so Senate to House, House to Senate. Usually, ideally, bills that don't make crossover would not be considered later that session. However, we've seen where language can be inserted in other bills later on, even though they've not made crossover. So while crossover is a deadline for legislation and tracking it, that doesn't mean something can't come back up later. But this is one bill that is still active, that is a statewide repeal of the Senate Bill. Here, House Bill 253, this is our local exemption bill, sponsored by Representative Baldwin. So again, this would be restoring downzoning authority for Henderson County, all municipalities, but specifically only for farmland preservation and floodplain management purposes. You can see this was introduced or filed on February 27th and really has not had any activities. We also have our other exemption bill, Senate Bill 137. This one also restoring downzoning authority to Henderson County and all municipalities. This one is just for farmland preservation or farmland protection, sponsored by Senator Tim Moffitt. This one also was introduced and has not had a lot of activity. Lastly, I believe we have Senate Bill 419. Actually, there is one more after this. This is the Senate bill, basically the companion bill for that first House Bill 24 that also would be a statewide repeal of Senate Bill 382 or Session Law 2457. Again, not a lot of action on this one. And then the last one, where there has been some movement, is Senate Bill 587. It's called Clarify Non-Conforming Uses. If you remember in Senate Bill 382, or the downzoning provision of the session law, it talked about expanding the definition of downzoning to creation of any non-conforming use. This bill addresses that, but also, at least in its current form, has the statewide repeal as well. You can see some highlights there about defining non-conforming uses. I think when we first brought this forward, you remember there was no definition. There was a lot of vagueness in the session law language. So this clarifies a lot of that, but right now it still has the blanket exemption statewide in that bill. Any questions about those?
Yeah.
Before I move to House Bill 765.
Yeah, the Jennifer Falcon version, it expanded. I'm familiar with Tim Moffitt and farm preservation. Jennifer Falcon was, I don't know, also the management plan.
Is there, well, ask her while you're, I'll ask her right now. Why, I mean, is there any definition for farmland preservation? Okay,
As defined in the bill,
yeah,
but no, as it's written, no.
but there are bills sponsored by those legislatures or one or the other in different other counties or municipalities that they represent that don't have any, correct?
Correct.
Okay.
Okay. So that stuff is all pending TBD.
Yeah, again, ideally. So again, the crossover deadline is the same day as the council meeting, so we're gonna be updating this presentation or the presentation we have for council with any action that happens that day. Today was a pretty busy day in the legislature. Again, everyone's trying to get their bills passed through committees and into the other body to make the crossover deadline. But again, I'll caveat that by saying that that doesn't mean language can't appear in a committee substitute for another bill later on in the legislature.
Okay. No, and maybe you need to cover House Bill 765. But I think one of my questions, and maybe the board's questions. So if it, let's say one of these,
Mobile?
local bills. Well, not even one of the local bills, maybe one of the statewide bills that just overrules it, you know. Makes the crossover. Then we know that it's at least made it over one hump and it still now needs to pend in the other, in Senate or House, whichever one. And is there, like, we knew this crossover deadline was coming, is there another end point to when we would expect if something makes it through? When those would, is there a session end date by which we would expect action, or we're back into a waiting zone?
I believe it would be the end of the legislative session, which I have to look up. End of the calendar year, I believe.
Okay, great. Okay, good. So
Or,
up until
or,
this,
or until they vote to come out to close the session.
Okay, so it would be, you know, great news to hear that a bill that is looking to overturn the down zoning statewide makes it over to crossover, but on the other hand, that means we could still be waiting for the rest of the year to get a resolution. Is that
Yeah.
fair?
We will have to wait for, like, let's say it's the House bill that makes it through. We would have to wait for the Senate to take action on that and vote.
Okay,
And the governor decided.
Correct.
got it. Well, I mean, that all happened real fast last time.
With the end of the year. Everything in the debt bill.
Yeah, no, I do. Yeah, okay. All right, so it's possible that it would be a similar situation where if it is gonna be acted on, if we may not know anything until the end of the calendar year.
It's possible.
Possible. It's also possible that they could vote on it and we could have clarity sooner. Okay, well, again, and we can table this part, but obviously my real question is, okay, if it all passed somehow soon, you know, what steps we as a board need to be ready to do in order to act?
The council already has the rezoning on there.
Right, so we don't need, it will just be. a
We have
council-
lots of other things to do, but the council could take that up immediately.
First action.
Yeah.
Right in there.
They're hyper aware of that.
Okay, excellent. I just wanted to make sure that we all. Okay, great. Let's hear what you have next on, unless anyone else has a question before.
I'm sorry, I didn't hear what you said about 765.
Oh, just that they're constantly filling with it. It looks, well, I'm predicting the future. It looks like it's got some legs. There's already been 3 amendments to that one.
I'm not
And
familiar with what
it
that-
contains the repeal of the downzoning issue that you've been discussing, but also contains a lot of other things. And so it's almost like they're taking all these other ones, the downzonings, and putting all of that into pushing this one bill. But 765, they put it in there. They keep adding things. They keep coming away from, I think the most, what did you see today? The one that jumped out to me was they changed the language from allowing moratoriums for public health and safety to any legitimate purpose. They changed the shot clock from 10 days to 14 days. That when I say shot clock, you know what I mean, the time within which decisions have to be rendered on any application.
So I didn't realize anything changed today when I asked Michael this Friday, but Michael said he would be prepared to present to us. So for the couple of people that just said, what is that?
Yeah.
It's not what we're looking for.
So overview, House Bill 765 is an omnibus bill, so it has an overhaul of a lot of different aspects of local government development recommendations. My understanding, you can see the last committee substitute was on April 17th. That version had the repeal repeal of the downzoning provision in it, but it also had a mandate that cities of our size would have to build a minimum density of 4 units an acre, period.
Did you guys hear that part?
The-
Removing our downzone, but then require. It wouldn't happen without public sewer, because we have different health department issues. But if that gets solved and public sewer is spread out, we are quarter acre.
So that was the largest concern, that was mandated minimum residential densities of 4 units an acre. And I believe it was cities under 20 or 15,000.
Statement.
But this is the current committee substitute. Again, this doesn't mean this can change, but I just highlighted a couple of the main provisions. One thing they've outlined, and it looks like this is gonna stay, is the legislature has stated, basically municipalities or any local government is only allowed to do what is explicitly authorized by the statutes. So we've always operated that way, but obviously there's always been a legal gray area, room for interpretation. If this passes, and again, I'll defer to the attorney here, but my understanding is that wouldn't be the case anymore because. the
It certainly
statute-
gets to be tighter.
Yeah,
It has to be expressly allowed, which means in writing and detailed, and if it's not there, you don't get to say, well, it doesn't say we can't.
That's precisely.
When that changes and it doesn't say we can't. You guys understand how narrow this conversation becomes?
That's the,
Sorry, I didn't
the
mean to-
Dillon rule, but is that a narrowing of the Dillon rule then? Where the,
in a way.
Sort of, I
Yeah.
guess. I mean,
it's-
So, yeah. we
the
operate-
state grants every bit of authority. And so if you don't follow what the state's authority is, you lose it.
I feel like both that and the 4 units per acre were things that Chad alluded to in one of the meetings earlier this year.
I'm not sure who the sponsor of this bill is,
Well, I don't think it's Chad,
but no, well, he's not an elected official, so it's not.
Um,
That's one item to highlight. Again, just the narrowing of the interpretation. A lot of stuff here about, development approvals, I wanted to highlight this, but vesting of development rights, the standard was 2 years for that. That's why our subdivision plans have a 2-year expiration period. That's being proposed to move to 5 years.
Sidewalks have to connect with other existing or on the books planned sidewalks. Any place.
None of those sidewalks to nowhere anymore.
That's correct.
Yeah, they're all over the place too.
Here's the time period for approval, that Mr. McKellar referenced. So again, setting, there are currently shot clock or time periods for development approvals. My knowledge is for, DOT reviews and for building permit reviews. So far, to my knowledge, that has not been the case for, let's say, a zoning permit. With this, it would, so establishing 14 calendar days, for a local government to determine if the application is complete. And then a 90-day review period.
So you have to be done with your administrative review within 14 days,
Completeness review.
completeness review.
And, I counted this part. Failure of the local government to meet any of these deadlines is assumed to be approved.
Come on. Jeez.
Let me think.
So they could just inundate you if they wanted to.
welcome to North
Application.
Carolina.
And then this is another one Mr. McKellar alluded to. So normally our zoning statutes, are based on the police powers of the municipality, protecting the public health, safety, and welfare. This language changes that to, instead of promote public health, safety, and welfare, to reflect the actual and legitimate needs of the community. So instead of making land use decisions based on public health, safety, and welfare, we would need to start probably reflecting this in our decision-making if this bill goes.
There would probably need to be an extra level of, right now, in order to make a zoning change, there has to be a planning board approval, review and approval. There would probably also need to be a second level added in. The way I look at it, a second level that says this also is actual and legitimate need of the community based on this testimony.
Like a statement of consistency affirmation of,
It's like an extra statement of consistency affirmation, yeah. Related to legitimate need of the community.
it didn't say disregard to health and public safety,
Well,
right?
it seems to me that they give us a lot of leeway throughout this, but is offset by the fact that it's 4 units per acre. You know, I mean, you
This
can do all of this, except you still have to adhere to 4 units per acre.
Well, I've not gotten to that yet, but
Yeah.
before you just.
Yeah.
It's actually not included.
It was taken out.
Yes.
Oh, okay,
It was there until this morning.
Yeah.
okay.
So I didn't know that when I asked Michael to present this.
Parking spaces, any type of parking space requirement is gonna be deregulated. Can't ask for space sizes or number of spaces anymore. That's been in there.
Or did I just see handicap
Except
designated?
for hand-
Okay, I was like, dang.
Yeah.
they're
That's for
very
ADA compliance.
Yeah.
We already do this, but the design standards for public roads in a development. So again, our subdivision ordinances, we always default to NCDOT road standards. We're safe with that, but I just wanted to highlight that, for like city of Hendersonville or another city that takes over roads, assumes, maintenance of those roads. You have to, if this goes forward, you would only be able to require what NCDOT. Here's the sidewalk provision. This is impactful because in our TIA ordinance, our traffic study ordinance, one of the stipulations in the ordinance is that if you're within a quarter-mile of a destination of significance, it could be a trail, a shopping center, or a school. Right now, we require the developer to provide some type of connection to that development. That would not be allowed under this language unless the town's gonna connect with it within 2 years after the development. So, again, the sidewalk to nowhere arcs. All residential zoning districts should be classified based on density, not minimum lot size.
Hmm.
And then this is where the 4 units an acre.
That is in there, that's proposed to stay in.
Just the classification.
Okay.
Yeah. So like, if we went back to rural residential, we would classify it based on the proposed 1.5, or what was it, one home for 1.5 acres.
But is that? So if it's a parcel, whatever, 100 acres or whatever, then you can count the number of dwellings that could be there. But then. Could
The ordinance will only have per acre. It won't go into all the other sides.
Basically, it's about moving the zoning regulations towards density and away from minimum lot size.
Right,
So
so
think of MR30. MR30 is Mills River, well, I always say low density residential, but 30 for 30,000 square foot lots. Well, it won't be MR30 anymore because unless the density is still one home per 30,000. But if you go down to the next line, permitted uses in cities, this is what changed. So the first line here says an area zoned for residential use in a city with a population between 55,000 and 100, I'll just round out 25,000. You can cite no fewer than 5 dwelling units per acre. In the previous version, there was a line, and I can't remember the exact number, but in a city, I think it was under 20,000 in population, maybe it was 15,000. It was no fewer than 4 units an acre. And that was what was concerning to staff, is basically no matter where in the town, if it's a residential zoning district, you get 4 units an acre, period, and we don't get a say. Unless the utilities.
The health department can't be overridden in that.
So that was recently changed in this version. We are excluded from that type of minimum density.
For now.
In this.
At 8 o'clock on.
That's not, actually I am, but, did you point out the, A5, the applicant, the farm purposes? Roll up one to that that. Yeah, you were asking about farm purposes before.
Mhm.
This is and I don't think it's different from the last version, is it?
She's saying bona fide farms are not impacted.
They're not impacted at all by any of this, so.
Or any open space land.
Yeah.
purpose.
described in that other general statute, which we don't even know what that description.
There's been some changes to what you could, or proposed changes to what you'd be able to do through conditional zoning. So now the statute or the draft specifically states that we cannot require a condition, requirement, deed restriction not specifically authorized by the statutes. Originally, when we talked about conditional zoning, we talked about it being, this open tool for negotiation. So, the developer may cede on some things in town to get what it wants. Let's say that would be land preservation, or let's say it would be a kayak put in dock, on the Mills River for some development down there. Unless it's in the statute, we now can't ask. So it curtails the amount of negotiating you can do in the conditional zone.
So would you review the conditional zoning applications to see if the use is in the statute before it leaves your desk?
No, I think the main concern would be, let's say, let's just go back to Brown Ridge. Let's say the Brown Ridge property was being developed and this board or council said, we are not approving this unless you agree to a condition in writing saying you'll put in a boat launch, publicly accessible boat launch sponsored by the town and wildlife resources.
But that's not in the general statute.
If that's not in the statutes, we can't.
Can't do that. Okay. So it's, we can't require.
Right.
Okay.
But I believe it also says, because again, before it said unless consented to by the petitioner in writing, that is struck. So I don't think they can agree to it either.
It says accept any offer by the petitioner to consent to any condition not specifically authorized by law. So it makes it incumbent upon the city, even if the petitioner says, hey, we'll build you a boat dock. And that's not in the statute or in the statutes or the ordinance, then the city has to refuse it.
Everyone could agree to the solution and no objections from anywhere, public included, but
Mhm.
the answer is still no.
What,
Yeah.
what would the,
Unless it's specifically authorized by law.
meaning that our ordinance would have to say in the conditional zoning application, the town can ask for a kayak dock?
I believe
Like,
it's a
it-
general
like,
statute.
What would it have to say?
It says by law. It
But-
doesn't say, it
So
says
what
authorized
is
by
this?
law. No regulations, any regulations, any conditions, requirement or deed restrictions not specifically authorized by law.
But could that be a town ordinance? A town ordinance is a law.
I thought it said statute.
I think it means the statute. And
Okay.
again, I would be
Okay.
less concerned with what the developer puts forward. If the developer is building, their 300-unit townhome development and they want to put a kayak launch for their residents, that's
Right.
fine, because we're not
Right.
requiring it.
Right.
But it gets into when the item comes before the planning board or council, and if that negotiation starts happening, that's where this gets called into play.
If we present it as a bartering chip,
And if it's
but
not
it's
allowed.
not allowed, then it doesn't matter if they agree to it or not, we can't do it.
I'm just
But we
trying
could
to-
pull something from state law and require it because it's state law or statute, right?
Yeah, we'd have to find specifically what we're permitted to do in statutes,
Okay.
and we couldn't negotiate only on those items.
Okay.
I know Michael's not done, but the reason I asked, this is just tightening.
Yeah.
Everything that's happened in the last 12 months. Sorry, Michael.
No, there's a lot. This is not applicable, but this is for large cities and states, any permitted use that has to be exempt. Conditional districts. So again, going back to facts, kind of like that statement of moving away from police power. So in a conditional district, the local government has to support its determination of facts and information and not personal preferences, speculation, etc. So again, it's almost like moving away, a little bit away from normal legislative decision-making.
Quasi-judicial.
It's quasi-judicial, because we're seeing facts and information being brought up. Legitimate needs, actual and legitimate needs of the community is the new thing. This one is interesting. There is also going to be a shot clock for rezonings. So it's the same thing as the one before. It's 14 days for staff review, and then the rezoning has to be decided within 3 months. Includes this board's review and council.
Does it have the asterisk at the end? If we do nothing, it's considered approved?
Failure of the local government. to
Yeah.
act
Yes.
Shall constitute an approval of the app.
Now, you can, there is language that, says you can agree on an extension of that, that has to be agreed by those parties.
Up to 6 months.
Yeah, but everybody has to agree to it and they already got their way. So why agree? If we're not gonna get to it in time, just let it go.
So that's a big change for rezoning. And you probably won't like this one. All subdivision plats are being moved to administrative.
Regardless of size,
Doesn't matter.
there's no, nothing. Okay. And that's statewide, 500 plus municipalities, or is there a population qualifier? Okay. Wow.
So any subdivision plat, any final plat, any subdivision review is administrative or to be made, I believe, by a group of staff or administrators, such as those serving on a technical review committee. That's usually where, like, for the city of Hendersonville, you'd have their planning staff person, the utilities person, the fire.
A staff person or a committee comprised entirely of staff persons. Is the language that she is.
Your volunteer time is not
So
welcome.
the governing board and what you guys are, a designated planning board or another review committee, to review subdivisions, that is struck out of the statute.
We'll have more time for the other committee.
Mm-hmm. Land
Gonna
preservation.
need it.
Yeah.
Tiny houses.
Tiny houses, are allowed in residential districts, although I believe this is only in cities of
Population.
over 125,000, but I just wanted to highlight that. This is new too, so there's other bills out there that would, you'll see this on Thursday with council, that would permit accessory dwelling units for any single family home statewide. Those are separate bills. This bill has something about accessory dwelling units. I believe in a previous version, it was a statewide permitted mandate. It now states they only have to be allowed by right in large cities. So again, cities of 125,000 folks.
And it doesn't override.
So this does not apply to us, but I highlighted it because there's other bills out there where it would apply.
The ADU bills that are out there
Correct.
don't have population qualifiers
They
on
don't.
them. They can't override declarations by developers. They can
That's
have, yeah, so it's,
Private covenants can still govern, but obviously enforced through private legal
so
counsel.
that whole ADU conversation is huge and it's separate. It's not even on this bill. It's a lot of people have asked me if it's gonna infringe on their HOAs or their covenant, and developers covenants are, they take precedence in this conversation. They can't be retracted.
That's another bill that's pending right now.
Yeah, that one's coming.
I'm not kidding. It
Yeah.
really is. There's another bill about HOA, removing authorities from HOAs. A different discussion.
I believe that there's a lot in here about water and sewer allocation process, but none of that.
That's one of my questions in a minute here, so I don't know. Hopefully it's not applicable, but go ahead, please.
Yeah, that's the end of my summary.
Well, you're gonna have a lengthier presentation Thursday?
So Thursday with council, we are reviewing every potential bill in each body, the Senate and the House, land use related that could impact us.
Do you know who the sponsor is this, or at least which house?
This is House,
This is representatives? Okay.
yes.
I don't think it's for anybody from around here.
There are, no.
There are multiple
Not as one of,
sponsors. I
not as
know
one of
that.
the main sponsors. Sponsors Zinger, Brody, Winslow, Cunningham, Adams, Branson, Clark, Dew, Humphrey, Johnson, Johnson Hostler, McNeely, G. Pierce, Pittman, Potts, Charles Smith, Tyson, and Willingham.
So for anyone listening here in Mills River, Jennifer Balcom is our representative. If this is in the House of Representatives, call her and express your desire for her to vote against this.
This is called the
So-
Save the American Dream Act.
Really?
The name-
Screw the
Yeah, they
Local
changed the name.
Opinion Act?
Save the American Dream Act.
Okay.
Right. But this doesn't include for our town of our size a requirement of 4 dwellings per acre.
right now, but they
Not
change them constantly. So one of the
No, I
questions I
got
had, and I didn't know that had been removed today. One of the
Well,
questions I
well, we
had on
only-
here is we can't, the whole downzoning, blah, 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 right? We can't do anything about that.
Right. What's
Yeah.
Michael's point? I mean, in late last year on page 332 or whatever, of a 332
Last
page
sentence.
bill, so.
Yeah.
Even if this crosses over, passes and all that,
Right.
things can be amended after that.
Well, that's why one of my questions is, and this may be a dead end, but we don't even have, I know the state has fee simple ownership of their beyond just utility easements and their, 280 is a great example. But my question is simple. Can we as a town, not necessarily this board, but as a town, can we put something forth about not allowing expansion of public sewer? Because as you guys know, that changes everything. And can we stop the expansion of public sewer? Because without it,
The city,
that can never happen.
the city can, not through the planning
No, no,
board.
I
The
get that.
city, well, actually you can't probably because don't you get from Hendersonville?
Well, so what I've always said is that we don't have control over it. If a developer pays for an extension and if it's in a state road right of way, we're
Then-
not involved in that process.
Right, so 280, 191.
If there's, if for some reason we enter into some type of interlocal agreement or a growth boundary agreement with City of Hendersonville Water, that's our water provider. And Metropolitan Sewerage District of Buncombe County is our sewer provider, primarily in the central and northeast section of the city. There are agreements we could potentially enter into with this entity to limit how far it can go, but I was gonna turn that back to you.
Yeah, I don't know. My experience is mostly in municipalities that have their own water and sewer. And so they
And
they
they're
control it.
encouraging growth.
And they can, and they're, well, they could be encouraging growth, or they could be using it as the control to stop by saying, no, we're not gonna run sewer out, a mile outside of city limits to an industrial plant.
I'd let
It-
this line, I'm sorry, go ahead.
What I was gonna say, so I don't really know. My guess would be, these both being independent authorities, any agreement could be reached, interlocal agreement could be reached. General, we can reach an agreement with the airport to prohibit flight paths over Mills River. It ain't gonna happen, but you
Right.
could enter an agreement.
Right.
And that would be enforceable because an agreement. So I would imagine the same thing applies, Michael, but I'm gonna caveat that because I haven't researched it.
Well, my line of thinking there was, again, I opened it with, I'm not sure if this board is even the place to start it, but I'm intimately familiar with the health department's rules, and if we don't have public sewer, we could put a shield lower than maybe we want it, but higher than that garbage in place, because they're not going to, a quarter acre, it's just not gonna happen.
Well, that was my point. I mean, early in the year was we need to have a meeting where we focus on ways to put forth before the town council ways to maintain the rural character of Mills River that don't violate down zoning
Right, that's my question
and
for
that sort of
utility.
thing. So I would want to have a meeting where we literally focused on all of those ideas, knowing that this is going to change. I mean, I think there was not an appetite for that because, well, let's wait and see what happens here, but anything can happen at any time. Going back to your discovery of 2007 and the mayor saying, well, we couldn't bring sewer out there, so we didn't worry about it at that time. We need to worry about it because the people who want to come in here and use up the rural character of Mills River to build whatever.
I have a boring permitting question for you. I'm assuming you're familiar with O'Hollow's sewer line that was recently run around the perimeter of the schoolhouse and up to the back of Van Wingerden, which is then pumped to Bold Rock, which is then pumped to South Buncombe somewhere.
Recently installed?
Yeah.
No, I'm not.
Okay, well, I've been
Okay.
watching them for weeks out of my front door.
Yeah, and again, there would be no reason for them to involve me
It's
because.
pump
we're not,
up.
you know,
Right, right. So the question is, and I have some neighbors going, what are they doing? Everyone's asking me, like, I know, but I found out they were putting the sewer. It's all pumped. Obviously, it's fighting gravity to go from my house at the bottom of the schoolhouse at Ladson up to Van Wingerden, where there's another relay. my reason for bringing up this boring question is somebody, I told everybody, you know, it's just a matter of time before I get up, you know, 200 houses next door and that was sewers there. And they said, well, if it's expanded on a pump system for commercial or industrial use, and at their expense, that residential developers are not allowed to tap into. And I said, that is brand new to me.
I've
He-
not heard that.
He's
I mean,
adamant that that is,
I've worked other places where the developer has so much invested in their development concept. They're gonna
Would-
pay for that upgrade on someone else's property, the pump station. To accommodate their.
The volume,
needs, the
sure.
same volume.
sure. Okay, just, I'm only I really want an answer to that. I'm not sure where to go with that because from my driveway across the street behind Ohio, all the way to Bold Rock and beyond is all pumped and relayed, pumped, but it's all for, as you know, Bold Rock and all these other.
And again, all public sewer in Mills River is done through Metropolitan Sewerage District of Buncombe County. And again, they bought the former King Creek system, which is why they have this segment. And everything in Mills River actually drains through one pump station at the back of UPM Rafflehack. So the back side of Broad Point Industrial Park. And Kevin and I were looking at this recently, and from there, it basically drops into the MSD main that follows the French Broad River all the way up north of Asheville to
right.
their plant. I think
Beaver
it-
Dam or wherever. it is
Yeah.
out there.
In our section, it's maybe a 32-inch line. Up there, it's like 7 feet wide.
Yeah.
You know, we're basically the outer limits of their sewer.
This is really boring and I know, but you guys know where I'm going with this. The density follows utilities. If it doesn't, you know, create the utility themselves. As Etowah did years ago.
So the question is, does the town, if not planning board as an initiator, but does the town have
There,
authority to place limits on extensions of sewer systems within the town?
at any level, is secondary roads, primary roads,
Right,
all
right.
of them, anywhere, do we have the ability to put that stop there?
Where do we get that answer?
I don't know.
Oh,
I'm
I think
asking.
we're presenting it now first to,
Michael, I'm sorry, man. This-
yeah,
We're having to get creative because of all of that madness.
Well,
There's actually something, section 27 of this. Yeah,
Unless
Bill
we-
765. If you roll on down,
Right.
it talks about wastewater systems. And I'm trying to go through this.
Besides the
rapidly to
population
figure out what
qualifiers,
it-
this entire bill is statewide, right? 520 municipalities,
Yes.
Yeah.
And counties.
all municipalities. I believe the 100 counties are in that 530 statewide, 520. But my point is, besides the population qualifiers, there's no exclusions geographically.
which is really strange since there's a big difference in rural.
Jennifer Balkan,
Rural.
Call her.
Development and, you know, the larger
So
counties and cities of of North Carolina.
Go down to section 30 of this same bill is called the Water and Sewer Capacity Allocation and Planning Act. You keep on going.
So,
I don't remember that being in this. And I'll stand corrected. I stopped reading after the ADU.
I'd say, I'll float this to
Yeah.
our town attorney, because
Uh,
either way, it's just gonna have to go.
Sorry.
Like council would have to enter into an agreement, to do some type of limitation.
sure.
But we'll find out.
Yeah, I think that's the question is.
Yeah,
what the town-
I've always defaulted to, that is a fee simple right of way for the state out on, as an example, 280 or 190. Fee simple meaning it's theirs, they can do anything they want. It's not on your property, it's theirs. And that we would never be able to stop it, but you know what, I've always made that assumption. I'd like to know that from someone else.
but for a major development, they would have to move far away from that. The sewer line.
But it has to get there,
Well, yeah, if it's not there, it can't go
right?
through the
You
development.
use
yet.
the Fulham
But
farm,
can it
right?
stop there, and not go into?
Thank you, Michael.
Okay. Are we,
Is everyone comfortable if we move on to the next agenda item?
Thanks for letting me add that one.
Of course. I think, Jenny, would you like to kick off this
Yes.
topic of, talking about our subdivision ordinances and, potential amendments?
So this kind of ties in everything that we've been talking about tonight. How we see Mills River, what it looks like. How we can define that for others going forward and give a level of expectation. Like I said previously in the, general section of the subdivision ordinance, it does say within or related to. So I do want us to discuss about taking the related to out so that all of the provisions have to be within the actual subdivision itself. The other aspect of this is, there is quite a bit of ordinances in the subdivision aspect. I would love for us to review like a section or two of it, like every meeting for maybe the rest of the year. Instead of biting off the whole thing, just take it in bite-sized portions. I noticed when I was looking through the ordinances for subdivisions that we have not taken into account historical, ecological, cultural aspects of what we would like to see in Mills River. Jim, you were talking about like how trees are trimmed when we were talking about Publix and stuff like that. I know that's completely different, but those are things that we can talk about. In the lighting section, I personally would like to see us a little bit more ecologically minded. We have millions of migratory birds that fly through here right now. We're blinding them. I live next to the airport. I know all about light pollution. Every night I can see around my house at 10 o'clock at night. So if there's any way that we can help our future residents and maybe even our current residents maintain or retain some of these aspects that they like about being in rural Mills River, I want us to be able to define that and really give a good idea to any developer, whether that's high density, whether that's subdivision, like really give them a good idea of what we want Mills River to look like. So, pretty quick.
About what you're thinking come up in the UDO
Yes,
question.
but the UDO also needs to know what we see Mills River look like. So until we give them that information, they're just working with the legal definitions of stuff, like pavement, what does that mean? And if we decided that as a town, we wanted purple pavement, that's what I'm talking about. Like we need to describe and define Mills River. And I think this is one of the ways that we could do that to help our residents move forward.
That's what I'm saying. We need to make sure that's conveyed to UDO.
Wouldn't the first thing that you mentioned, changing where would that not run against downzoning? Wouldn't that limit usages?
So we're really,
Moving the related to portion.
Yeah,
what Ms. Seeley's talking about is specifically the definition of common area, recreation area. Right now it says land or a combination of land and water resources within or related to development. Again, because related to is in there, that's why the Millbrook Crossing Trail goes on the parcel, not the subject. Because how do you define related?
It's too.
So there's two things I'm hearing. One is a text amendment to the subdivision code, which if we want to get moving on that quickly, the board should initiate that tonight. And again, we can look specifically at these two definitions and scan through the subdivision code, make sure there's nothing else we're missing regarding that. The other item I'm hearing is just a general review of the subdivision ordinance in general, chunks at a time, so we can then have notes to inform the union.
So let me ask something, and you know I'm a fan of what you say,
Yeah, I know.
but I also am a fan of if the neighborhood wants to do it, then they should be.
Yeah.
I know it's not, no, your neighbor is an HOA's clubhouse, right? The Homestead Mills River Clubhouse is by Woodpecker Sawmill.
Yeah.
Homestead Mills River is, what, 3 miles away? 3 miles up the road. The neighborhood has no problem with that. They have, I don't know that.
But that's not a trail either. That's not made
that
for them.
wasn't Trails, that was common areas, and this is common.
Well, it's common or recreation.
This is both.
So
Right.
There's two things. We can either do a text amendment for just the definitions. We can also amend pedestrian facility section of the code if you're trying to get specific for trail.
And again, you know, I'm a fan of it, I just want to. Conversation has to be open and thoughtful. from
Correct.
Every perspective, and the residents of Homestead Mill River, they have no problem. They
What?
prefer it be there, but guess what, that river.
Yeah.
So it's over by the sawmill, because that's where the river. And they are hungry. I don't know. if
But
we wanna
was it-
require it.
So here's the
And
thing.
we thought you want without taking their rights.
That's a really good question.
And again, on this trail example.
Yep.
100% way.
Yep.
Don't want to tell the neighborhood they can't do what they would if it makes sense for them.
Well, I'm also talking about everybody moving forward, not for.
No,
the
no, no, I know
Homestead
that.
Way.
That example is
I
not even
know.
Mills River. That's
know.
actually Horseshoe anyhow. The Homestead.
Yep.
Yeah,
Well-
Homestead's in Horseshoe. So that was just an example of, obviously, we're not gonna backdate fire comment.
Yeah.
They're not gonna comply.
Can I ask a question where is this only applicable to the developer of the subdivision, or would this be applicable to the subdivision going forward? Meaning, so it's kind of in this example, what you're talking about is like, one, we're kind of talking about the building of a trail by the developer to comply with the subdivision ordinance. And again, knowing that it was just sort of an example, and I think it was a good one, of where an HOA or a neighborhood sort of chose or opted to build their neighborhood community center in a different location. So like, I guess I'm, which seems to be like, again, we want to protect an HOA or a neighborhood's,
They do what they.
the
want to.
property collective owners to be able to do what they want, whether it's related to or within, but to limit a developer's ability to only be within.
Let
Is
me
that?
give another
Yes. Yes, that's what I'm talking about.
Yeah.
Limit the developer, because that's prior to the HOA creation, right?
Right.
So like if the HOA, so I have a question. So if a subdivision, creates an HOA and then they decide that they want to add, a community center 2 roads down, that's not near them, does that even fall under this purview?
Because it's just private development.
It's like
We-
they're gonna take
we-
form of an LLC or some type of.
Yeah,
nonprofit.
we would
Okay.
be looking at subdivision applications, in this case, major subdivision applications, which most commonly are coming from the developer.
Yep.
We're reviewing the initial stage.
Okay,
Not a community that wants to pool money and go out and do something. That's just the.
okay,
So,
okay.
so let me give you one more thing to think about. And
Yep.
at what point in the process, Michael will help out here. The master plan has to be submitted to you, but it doesn't have to have, a plat for residential lots in phase 4 out in the future in this example, right? So the conversation, in other words, where way before, because I think what these residents care more about is that they were misled.
Correct,
Not the final, if they were told about that trail around the storage unit up front, they could have made a more informed decision. And whatever they decide is none of our business.
correct.
So at what point in the application process could that be triggering, anything, fill in the blank, trails, whatever, that disclosure? So the master plan is sent in as part of their application
Yep.
process, which under this new bill is administratively, that's
So-
just a ministerial approval, but could that get you what you want? Disclosure up front.
So the thing is like, in the developmental stage, this is an expansion from a minor subdivision to a major subdivision if we use this past example.
Well, it became a major one far before that.
Yeah, to fulfill, well, major is over 100 houses.
No,
It's not?
no, that's a pathways trigger.
All right.
It just triggered something else. It was a major
Okay.
well before that, but I know what you're making,
Yes.
your point still.
So, you know, like minor subdivisions, you know, they have their own provisions, but when you're kind of like upgrading, you know, to that major aspect, I think, you know, our previous, case may have been like a poor example of all kinds of like madness going on at the same time, like everybody wasn't organized enough on the front end to really know their vision and how they wanted to move forward. And so I think at the beginning of the development is when we should see like what, how they're going to fulfill these provisions.
So unfortunately, and
Yep.
I'm agreeing with you, and that's why I'm feeding that out there, because I think that's the best route we have to police this.
Yep.
But they did sign some type of, I'm gonna call it an affidavit because I don't know what the term is in the application that says if we grow beyond X amount, we understand that we have to be compliant at that point. And they just didn't see it or thought they were gonna muscle their way through or something.
But that's not our problem. I mean,
That's
like,
not our,
exactly. So, you know, that's the reason why I think if we can take related to, because that is too ambiguous. That is, you know, like, let's make it 2 counties over, or hey, I'm going to attach a walkway to a park. And now I can expand, you know, another 50 houses kind of stuff. So I think that term related to is too ambiguous to be at the beginning. We either have restrictions and, you know, rules and obligations that you follow. And then, you know, the enforcement comes later, but these are what you need to do up front for what you want. And then everything kind of moves forward. Of course, you got people moving in and HOAs and all that nice jazz, and they can take care of themselves.
I mean, I agree with removing that. My question is whether that's violating the down zoning because you're limiting use when you remove that. I mean, I agree with you completely. I'd love to see that removed. I'm just saying, are we gonna chase something and spend a lot of time on something's gonna violate?
Wouldn't the question
down
be
here?
creating a nonconformity?
which we can't do under,
Well, and I'll double check, but my interpretation is that if it's from the subdivision ordinance, it's only for new subdivision applications. You know, once a subdivision's approved, we don't go back and look at it unless there's some type of violation, which would be a separate enforcement process. But if you're looking at changing a definition, we're basically clarifying a standard in the ordinance that's only applicable to new subdivision applications.
I think it would be valid.
Okay,
I think it would be allowable because it is a definitional change. It's not,
limiting you.
it is limited.
Applicable to existing.
it's not applicable to existing units. You're not creating a nonconformity. That's really what the downzoning is for, is to say, okay, you've changed your rules in your zoning district. That's gonna cause some pre-existing lot to be out of conformity.
Right.
And you're not doing that in this case. This would only apply to new subdivisions going forward because the subdivision already exists.
So then why
That's it.
couldn't we, I'm sorry to,
Yeah, no, that's fine.
in that case, why couldn't we say in all new major subdivisions that the lot size needs to be an acre and a half?
Change definitions all over the place if
I
that.
mean, that's only for new subdivisions. That's not for existing subdivisions.
Well, that changes it changes what they can
Changes the
develop. Whereas what we're talking about here doesn't change how many houses they can put into the major subdivision. It just changes, it's sort of like this ancillary, you know, this.
Well, as Mike continues to point out, it's not just number of units per,
Right.
it's use.
But
So
it
can-
doesn't change the use because you can still build all the houses. The trail or pedestrian walkway is not a use.
I'm leaving that to someone else.
And it is a requirement already, that it be a sidewalk or a walking trail. So the requirement is already there. They already know that that's required when they do that. So they can build that into the initial plan as a forethought
And that's my point. If you take out the, can't remember the word,
related to.
related to, then that may limit the number of units because they have to preserve land for.
For the trail.
sidewalk. Right.
Well, they would have to do that anyway.
Not if they use the
No.
related to, not if they build it next to it.
Well, say they only, so let's use this example. So say they have 10 acres, we're gonna use one house per acre, easy math. Now, they know that they can get 9 houses in and say the requirements there for the sidewalk, just for easy math. So they leave that core or that last acre to actually do the sidewalks. I mean, that would be the initial part of the plan, I would think, because it's required. So how they do those sidewalks is what falls into our purview, correct? Like, we are already telling them that they have to have the sidewalk, it has to be this wide, it has to be, you know, like like this kind of lighting and whatnot. We're already giving them specifics on, you know, like what is required to be inside of it. We're just defining that it has to be within, instead of like the sidewalk to nowhere that just happens to attach to the last house on the end of the street, and it was easy for them to do.
Well-
Which would then allow them to build 10 homes.
Yep.
And you're telling them they can only put 9. I'm not, you know, I want the same thing
I
you're
know.
going for. I'm
Well,
just
Max
not sure the
says-
legal.
Max
path.
says yes, so we get a yes, you stop at this.
We just did it. We
or-
just reduced their use, their allowed use. What does this sentence read like? Jenny, the way you want it, what does this sentence sound like? Can we let's say it the way Jenny wants it so I can,
Well, all it is striking out related to.
right, I don't have the sentence in front of me though.
Yeah.
Land, common area or recreation area definition. Land or combination of land and water resources within or related to the development for active and or passive recreation. The public or private use of the enjoyment of the residents of the development of just game with various.
So by moving related, you're leaving within.
Yeah.
Correct. That's it. That's just the definition. That is just the definition. It's like saying lighting is, you know, like a rainbow. I mean, it is literally just a definition. Because they know that they can read lower about what those requirements are, like how many square feet for regardless of what it is. And, you know, like this also applies, this could apply to all the lighting requirements that we have, or, you know, anything that is a requirement for a subdivision. You know, it should be within the subdivision. If you're gonna have street lights for your subdivision, they should be in your subdivision, not down the road.
Look, I'm a fan of this,
I
you
know.
know that.
I know.
I'm even a fan of passing that language tonight. I just don't want everyone to, I see a legal argument against it.
Well,
for
and I
downsizing.
see what your argument is. Your argument is that if you're required to put these amenities
It's
within the
changing
subdivision,
My
that
development.
that it
ability.
changes the ability of anybody who hasn't developed yet, and therefore you're sort of kind of down zoning.
You're restricting their use. I'm just saying it's a
Well,
legal argument, but what do I know?
There is perhaps a legal argument to be made. The thing is that you could achieve the same goal by changing the word or to the word and.
Yep.
In the same spot,
So there you go. That makes me feel better.
And-
related to.
That makes me feel better.
which means you're just changing one word and you're saying within and related to. And you're just clarifying what the definition is. You're not necessarily requiring common space to be put in there. It says just if common space is put in there, that is, here's how
Within
it's
and
defined.
related.
Maybe that's the workaround.
Yeah, well, cause again, let's just say it's not applicable to Mills River, but if we were an oceanfront community, the oceanfront could not be within our community. It would be related to, or, you know, in this case, maybe it's riverfront. Riverfront is not gonna be necessarily within, but by saying and related to it. Does that sort of? make
I'm fine
sense?
with this for now. Our UDO is addressing subdivision ordinances, correct?
Yeah.
So there's gonna be a lot more discussions on.
Well, and I think what we
Well,
were
this-
proposing was a text amendment
Text amendment
for
to
next
next
time.
Yes, to get this through as quick as we can. So
So
that
not
applies to
even,
any
all we
speaker.
need to do is make a motion to, do we need to make a?
Can we
motion?
not push this through tonight? Right, right. For our part, take it back. So our next meeting would be it.
I would prefer or recommend that there be a motion and a vote tonight, so we have it on record, the formal action forward. And then staff
Okay.
would bring back the amended text or just change it for the and at the next meeting.
Sorry, that was the question. Not just consensus. We could vote on it, right?
You-
I hate to prolong this. I'm not sure how and changes it.
They have to meet both,
For,
correct?
To me, the question is whether you have the ability to clarify a definition or not under the downzoning, under that downzoning amendment. And just to be frank, the downzoning amendment is unclear enough as it is. You're never gonna pass a perfect ordinance, but I think that by adding the word and clarify the definition as defined, if that is what city council wants to do, because y'all aren't passing anything,
Right.
you know, you're making recommendations, yeah, or town council.
my God, I don't know.
And
I feel
and
better about putting my name with it.
Right.
you're less likely to be driving the truck into the wall. You're more likely to avoid the wall. And
But it still allows the developer to do the
which,
Related
and to be,
But
and to-
it's to be within and related to.
I got you.
So it has to meet both criteria because it's an and.
but you know, I'm gonna play lawyer for a second, caveat this by saying that all the more reason to let Michael to put it on the record. If you're generally in favor of it, let Michael actually draft the language and bring it back, which would give us a chance to double check and look and make sure that we're not running afoul. I feel like this is close enough to a definitional change. And so I'm much less concerned about it, or not a definitional change, clarification, not even a change at all. But I'm gonna play lawyer and give myself that little bit of leeway.
So you asking for a motion or you just consensus tonight? Motion?
Make the motion.
I would like to make a motion to change the verbiage and what is that like?
Subdivision ordinance amendment.
Common area and recreation, definitions. To change the wording from within or related to within and related to.
Second.
We have a motion on the table. You guys, we need a vote in the affirmative.
Aye.
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 I think that was unanimous. Yes, unanimous, aye.
So back to my other thing about adding, segments of the ordinances
I think.
to review.
Yeah, I think that we can definitely, my suggestion, and given just the time, is maybe bring, as the suggested one to discuss at the next meeting. Perfect. And rather than, if you want to, because we appreciate, your targeted review of this, I think go ahead and maybe highlight what the next big thing that might be useful for the board to discuss. And we can bring it to the next meeting, which segues to our next topic, which is, may we adjust the June 3rd meeting?
Well, you can't make it 10, Brian, right? So it doesn't have to be on a Tuesday, or does it have to be on?
Are you talking about our normal meeting,
Yeah,
which is the third?
third.
Right, but I'm saying I can
Right.
get that, but you can't.
And
put
I
10.
can't make it.
What,
I'm sorry.
when,
That whole-
are you available?
I'll be back on the 6th, which is
June
Friday.
6th. Okay, so, and Brian, you're out for that.
I am the week of the 9th, I guess that is. You are too? Okay, so we've got two no's, so I don't mind missing one, but we're pushing it.
Well, it would be, could we move it to instead of the 3rd, the 17th? of June, which is 2 weeks. So instead of our normal first Tuesday, it would be the third Tuesday.
I'd start with Patty and
Well,
Michael.
great.
if It's available.
I'm just throwing that as an option out. The 17th.
I'm available. I'm a yes on the 17th if they are.
We're available. We'd have to, check for course.
Okay.
Tuesday, you need a calendar
Good.
here.
Makes
It'll,
Tuesday, June 17th.
Okay.
it's my husband's birthday.
So the only person, obviously, we haven't checked with Lonnie, but, we can make this change without him since he's not here. Is that correct? Yeah. With a motion.
This is
but-
to change the meeting calendar.
Yes. So with those of us that are present, would someone like to make a motion to change our June 3rd meeting to June 17th?
Yeah, I'll make the motion.
Thank you, Mike.
I'll make the motion to change our June 3rd meeting to June 17th.
What? Voting in the affirmative?
Aye.
Done. Move it on my calendar right now. I had already seen it. Hopefully you don't forget otherwise. Excellent. Well, any other things before, any other items?
Yeah, I don't want this as a motion or anything, but at I think it was the last UDO meeting where Chad said, quote, "We can overcome 382," and one of the things that he said was, you can't limit the number of units, but you can limit where they go. So if it's 7/10 of an acre or whatever the land size is, can't limit the number based on the land size, but we can limit where they go. And I wanted to, using his words, lean into that, see if that's true,
We don't currently have any setbacks. Right?
or how we would go about it.
And I think, wasn't that tied to this concept of, requiring, or maybe not requiring, but like that there could be like sort of preserving open spaces?
Right.
Like that we can preserve the open space, which goes to like, you can have the same number of development units, but they have to maybe fit in a certain.
Right, and that's, my
Areas.
point was, that verbatim was, we can't limit the number of units, but we can limit where they go. How do we go about that?
That would be technical.
Yeah,
Like, that gets back to your exact question before, we're worried about tripping the downzoning of the subdivision ordinance. Changing setbacks or buffer yards, I think is much more likely to trip it.
That's,
Not-
I think that's even specifically
Yes.
that would
mentioned in
trigger
the,
non-conforming.
that's specifically mentioned in the statute.
Problem is our ordinances are so loose, right? I'm literally have no setback. Change that, you're changing how the developer or individual can use the property. I think it
But it triggers the non-conforming, not the number, not the
triggers down.
density.
It would, it could trigger the downzoning because what? Nobody knows what it's gonna trigger because nobody's had a lawsuit about it. So nobody really knows what it's gonna mean,
I guess
and
I-
it may not even exist in a few months.
I guess I
But
look-
having said that, things like reducing or increasing the reservation of space, which reduces the number of lots that can go in, is going to be more likely to cause an issue rather than simply defining a definition that's already in a ordinance. Clarifying. In fact, I don't know if you used the word clarifying, but I would hope the minutes reflect that it's clarifying the definition as being what's happening. But it's really discreet, and I'll be honest with you, I was on a Zoom call with about 200 attorneys for the state trying to figure this out, and nobody could. So it's a little bit of a gray area, to say the least.
There's a joke in there somewhere, but yeah,
I can check with Chad.
Yeah, I'd follow your UDO expert that's here, and
well, because to me, and I may be wrong here, but it's the flip side of what the developer did with these townhomes where they use the number of units per acre, but then densely pack them in because they had the ability to do it based on the language that we had in place at the time, right? And so why can't we do that same thing with zoning? But we're not trying to limit the number of units, but where they go. And so that, you know what I'm saying? And so that, if we're trying to maintain the rural character of Mills River, the developer still has the ability for the same number of units, but we can limit where they go, green space or whatever, then that helps, doesn't hurt them and helps us accomplish what we're trying to. So I just wanted to find out more about how we go about doing that. And again, everything's fluid anyway, right? I got you, but that would be,
Right now,
I'm
we have that are gonna stop.
do what?
We have a minimum lot size, which under 765, they want to remove. They want density to it, not minimum lot size. Right now, we have minimum lot size. If you had X amount of acres that can take X amount, the max is, you can't get smaller than that.
But that's my point, that these townhomes did in some form or fashion.
They did that because they had floodplain that they could just not allow on.
Right, but but they had the ability to build in the floodplain if they wanted
That
to.
came from them, not from us.
I know. But they were able to do that. Why aren't we able to do that from our angle?
They voluntarily stuck it out there and it was allowed. It was the applicant who initiated.
Okay, well, I want, sorry, turn into a discussion, but I
Yeah.
just want to find out more about that.
Yeah.
Thank you, Michael.
Thanks for putting up with the long one.
Patty.
No, actually, well, it's not just for Patty. Let's be clear here. We're on video. Okay, it's for the entire staff, but the 9 o'clock is the cutoff. So you
Dude,
have
I
to talk
brought
for
them
10
a
more
baby
minutes.
donkey the other day, man.
That's right. I would save some money here, so. Oh, yeah, no suggestions, so. Public comment time with the.
Do we have?
Jim does.
What-
What-
Hold on one second. Sorry, I'm sorry. It's just we had a member of the public.
Walking trail and the sidewalk. Those river rock, gotta go down the road. We got. They sent up. Separate neighborhood, no association with Mr. Rock. The question is, can we do that? Yeah, is it a separate, that you have the application in? And we'd be able to work on. I'm just interested in where they're going with it. Are they giving up? Are they going? Money now?
Yeah, I don't think we know that, and because it's not in front of the board, it's not something we're able to, I mean, literally, it sounds like you have more information on that
Well,
than.
we can't
than we do.
speculate specifically, but as I alluded to earlier, they have a lot of workarounds, and that is one of them I mentioned,
So,
because I do have that
But-
information from someone else.
but at this stage, there isn't
They
anything,
don't,
we don't know, and so we're not, but it's possible perhaps by the now amended June 17th, 18th meeting. Maybe we'll have, maybe there'll be something in front of us at that point, in which case, they'll have to put those details into that application, but at this point, I don't think we have an answer.
So we have a complete application presented from our planning. We can't
We have no,
get into the details,
Okay.
fortunately.
so.
I second that motion.
Yes, I'm sorry, Jim. I didn't mean to interrupt you when you went to finally make the motion, but since I know that these members of our public have sat with us for the whole meeting, thought it was fair to just allow them to kind of.
we can do the microphone, good, and hear my only advice.
Yeah, sure.
It's up to you.
Yeah, please. I appreciate that you all.
Be very quick. I'm Joe from Mills River Crossing South. First of all, 2 thank yous. Thank you last month for listening to all the comments and deferring because it let other things unfold that we now see today with no walking trail, and that was very good. Thank you. good decision and an excellent discussion today about future trails and workarounds and trying to close it down a little bit.
Thank you. We
Thanks for
appreciate
coming in.
you. Thank you for coming in. And again, we say it every time, the public's input is all that matters. Well, not all, it matters a lot to us. So what we can do with it may not be, obviously we have to balance what we can. do
It
with
means
that.
a lot to
But it
us.
means a lot to us and it is the direction. Yeah, I mean, it's so important. So again, thank you for listening and staying here tonight and and those of you who can't see, who might be listening online. You know, it does matter and it was very impactful. The comments that we heard last time were very impactful, just as your own, as neighbors, you know, neighbor to neighbor. I think it meant a lot. And of course, within our role on the planning board, it has, you know, what we can or cannot do with that input is we are bound by our legal obligations, but as your neighbors, I think I can speak for everyone that you know, we all left that meeting feeling very heavy, but also feeling very full from being able to know that the community was standing together and had so much to say and brought their voices here. It's so important. So apply to that land preservation committee. Okay, Jim. Take us home.
I would echo what you just said in a few words. I'm thankful all those people came,
Yes,
and tonight they keep coming.
yes.
Now make my motion to adjourn.
I'll second it.
Aye.
Aye.